This is the third Ask an Expert session in a series that has seen topics such as the workplace and business safety in Simcoe Muskoka, legal and human resources advice on reopening and re-engaging employees. And recording of those past webinars can be accessed at the simcoe.ca/askanexpert, and that link will be populated into the chat shortly. Topics such as mental health, business planning, and marketing in the new era are still to come. And for more details on those, you can visit simcoe.ca/askanexpert. It's all located in the same place. So welcome to the Ask an Expert series brought to you by the Simcoe County, the small business centers of Barrie, Simcoe County, Orillia, and South Georgian Bay, the Community Futures Development Corporations of Orillia, Nottawa, Saga, North Simcoe, and South Georgian Bay. And I'd also particularly like to thank the town of Collingwood for providing use of their Zoom technology today, as well as Irene Taylor, Director and Human Resource Manager at Pace Law, who has been largely responsible for bringing and pulling together our team of experts. Today's session will be moderated by Don Jack of Pace Law, one of Canada's leading business litigators. He'll be posing your most pressing questions to Pavle Mazik, Jason Dutrzik, Andrew Kamen, and David Law. And with that, I'd like now to hand over to Don Jack to kick it off. So I think while Don and Irene are just sorting out a technical glitch, what we'll do is we'll ask Pavle, Jason, and David just briefly to introduce themselves as our experts in the panel that Don will be moderating and posing questions to. Pavle, why don't we start with you?
Oh, good afternoon. My name is Pavle Mazik. As you've heard, I am a partner with DS Lawyers Canada, LLP, in our Toronto office. I have been a commercial litigator and restructuring lawyer for a number of years now, and I've been practiced really all over the country, from files in BC to files on the East Coast. And I want to thank you for inviting me to speak today.
Thanks, Pavle. Jason, how about yourself?
Thanks, Tim. My name is Jason Dutrzik. I am also a partner at DS Lawyers Canada, partners with Pavle Mazik. I am located in Ottawa. And like Pavle, my restructuring practice has taken me literally from Vancouver, BC to St. John, New Brunswick, and everywhere in between. I've been doing this for approximately 16 years now. And the practice of law in business and in restructuring continues to evolve, and happy to be here today, and thank you for having me.
Thanks very much. And David.
Good afternoon, Tim. Thank you. And hello, everyone. I'm David Law. I'm the founder of a firm called Law at Work, which focuses on employment, labor law, workplace safety, and also nonprofit organizations. I have been doing labor and employment law now for a while, several decades now. And like everyone on this panel and like everyone listening in or watching today, we've all been through this extraordinary experience of COVID since February, and our work and our world has changed. And that's really what Pavle and Jason and I we'll be talking about today, is how these events have affected our practices and how they've affected your businesses and your organizations, and some key points that we can offer to going forward and to creating whatever the new normal will look like. And Don Jack, who is our moderator today, has some questions he's going to put to us. I don't know, Don, maybe you can thumbs up us if you're, are you good to go mute wise, or are you not? I can't tell. Looks like you're muted from here. So still muted. Okay. Well, let's, maybe while we're waiting for them to fix that, Tim, perhaps Pavle and Jason and I should launch in. And then Don has a pile of questions to hit us with when he's ready. And so why don't we start, what do you think we start with Pablo? Pablo, there's a number of issues that you and Dawn have prepared to talk about today that are important. And maybe we could start with you while we're getting launched. So what do you think people need to be concerned about now?
Well, so the first item, before we launch into concerns, I think an important thing that I'd like to, that Dawn was going to ask all of the panelists about is to go through some of the opportunities and bright spots that we can expect out of COVID. It's so I can start that discussion, then I'll hand it over perhaps to Jason and finish up with you, David. But from my perspective, I think that there's a real opportunity to be had from COVID. I mean, it's not all doom and gloom. I know this has been a trying time for many people, but I like to think of all the things that we've embraced. There's been a wide embrace in the business community and by the courts in technology, and everyone has invested heavily in technology. And I find that it's been a remarkable thing to bring people together. Our firm is a nationwide firm, and I find that I have stronger ties with people in offices outside of the Toronto office than I did before COVID. And that has been a real positive outlook for me. And I think it's important to take stock of all of the good things and it'll differ from business to business, that have happened since COVID, what you find that works, because your business COVID will end, but your business doesn't have to look the same as it did before when we emerge from this. You can see the things that have been stress points and improve them, and you can also and look for efficiencies that you can add to your business, but you can also embrace those things that have really worked and added to collegiality and added to efficiency. That's my perspective on COVID.
Blake, can you hear me now?
Hello, Don. Yes, we can.
Thank you very much. I'm glad we solved that problem, and thank you for leading off, because we did want to start with positive observations about business solutions. I have one myself, which both you and Jason are familiar with, relating to a very high-end real estate developer in the Durham region, the business was struck, of course, by COVID-19, just as they were getting into the sales season, and they had to close the sales office. They also found that the pool of prospective buyers had changed insofar as investment buyers, those who would buy and then rent out units, just dried up. And so they were left with end user family buyers who would be living there themselves. So what did they do? These are purchases from plans. And so what they did was they said to the prospective purchasers, who are the families who would live there, we, within reason, can alter these plans to suit your particular needs as purchasers. What would you like us to do? And that seems to be working, and we're now working out, as you know, terms with the creditors, given the delay. So that's the sort of business solution that I am seeing, but perhaps I would turn it over to David at this point. What are you seeing in this regard? David Law? Can you hear me?
Yes, I can. And like everybody else in the world, I'm still learning technology. And so the unmute button is a very good one to learn indeed. So anyone can catch that bug. One of the things that we've all seen is what we in our discussions have called the revolution of the reorganization, redistribution of work from workplaces to home. And in a lot of businesses, that's happened in large part or at least partially. So a positive from that, of course, has been, to the extent that it works, a lot of organizations are reevaluating their physical plant needs already. Almost every client I have has had to sit back and look at the footprint they have or the footprint they thought they would need in 2, 3, 5 years, and ask the question, do we really? So there's that. Another important consideration is this, and it comes from the hard part of COVID, which is that people have been away, some have been laid off, and organizations have had to reevaluate productivity questions, work process questions, and increasingly are making hard decisions about, who do we need on the team? Where's the productivity coming from and where isn't it coming from? And that is not a happy experience for anybody involved in it. So the word positive doesn't feel like a very nice word to use to describe it. But the truth is that organizations have had to evaluate that. Thirdly, and again, is this a positive? I'm not sure, but I'll open it up to the folks on the panel and for our listeners to think about, which is, I have seen a very strong and maybe predictable generational divide in management teams and in organizations that has arisen and been sharp during the COVID era. And that generational divide, this will be simplistic and stereotypical, but it really has to do with, in my experience, the most senior managers, proprietors, et cetera, resistant to, first of all, to the true risks of the pandemic. Secondly, to the organizational and tech changes that had to be made in order to survive it. And they remain skeptical. So what I see is that the most senior and experienced people very often do not like the work from home option. They think they're losing productivity. They think that it's costing them to have people at home for all the reasons that you can imagine. Whereas younger, more junior managers and associates of companies have a different experience. And I think this is going to produce, and it is producing, some very interesting discussions and some tensions in organizations that can be good or bad, depending on how they're resolved. Those are just a few observations, and I know Jason is chomping at the bit.
Yes, Jason, if you would address that, and we have to do so briefly because of time constraints, but what do you see happening?
Certainly. First and foremost, I would say, I think collectively we are a resilient bunch. From a personal perspective, commenting or picking up on what David just mentioned, our law firm is looking at its footprint, and we are reducing our space because we don't need it. And picking up again on what David just said about the generational divide, there are people who are resisting it, and there are people who are thriving under it. I, for one, I seem to be working more efficiently and getting more done from home. The lines of communication are there and established, not just with my partner in Toronto, but with my partners in Montreal and my partners in Vancouver. And then interestingly enough, I would say that on certain files, complex files, as a result of the court closures, we're required to work collaboratively with opposing counsel, which is quite refreshing, actually. And it's amazing what one can get done when you're working collaboratively with colleagues on files. From a business perspective, just quickly, I have spoken with a number of business leaders in the Ottawa region, and one in particular, a very large an owner of a very large construction company. And he too is evolving. His company is evolving and adapting, and they've moved more from kind of a time-oriented approach with their employees as it relates to tasks, to more of a just get the job done and report back when the task is completed. So less emphasis on the time it takes, more emphasis on the fact that the job is getting done.
Okay, so in the interest of saving time here, because we have a lot to cover, I'd like to go to the first nuts and bolts question, if I may call it that. And I'm going to pose it to Pavle, and it is this. If a business has to undergo a restructuring, what, in your view, be as brief as you can, are the required elements for a successful restructuring?
Thank you, Don. Yeah, very briefly, I would say there are three main important elements. First and foremost is understand your cash position. In any restructuring, cash is king. Always remember, if you have one takeaway from anything I say today, it's if you find yourself in a position where you think the status quo is not going to work, cash is king. The very first thing you need to do is understand your cash position and understand it very, very well. You need to know how much runway you have, because if, you know, all things being equal, if you preserve the status quo and your runway on operations is less than 6 to 12 months, that may sound like a long time away, but you're already in a pretty serious situation. But the good news is the earlier you spot it and the earlier you formulate a plan to get out of it, the more likely you are to succeed. So it's important now. I think I've heard the term bandied about a lot of the word hibernation in terms of businesses that were potentially struggling or on the verge of struggling before COVID. COVID happened and the world stopped spinning for a little bit of time. It doesn't mean those problems went away. It just means that you've had some time to solve them. Use that time while the economy is reopening to start formulating your plan now, because you've been gifted almost in a way an unusual one-time event of circumstances that have given you some time to formulate a plan to fix what's broken. And that is first and foremost. Understand your cash position and know that there is a plan that can get. I've seen some very negative businesses turn around. Once you understand your cash position, then you look at formulating your plan. And step 2 will be the most important part of your plan, which is understanding who are your important creditors. That's step 2. Most businesses will have 1 or 2 senior secured creditors who are very important, and I like to call it the first dance. It's a very delicate dance one, but your first meeting with that senior creditor will set the tone for everything that follows. Because if you have a successful, productive meeting with that creditor, everyone else will have to fall into line. I mean, generally speaking, that meeting will set the tone for everything that follows. I've seen that meeting go very well. I've seen it go very poorly. Generally, the meetings that go well are the people who have formulated a good plan, because what a creditor wants to see if you're coming to them saying we have a problem is not, this is a problem and you're going to see it in my forecast. It's, I have a problem, but here is my solution and this is what you can do to help me. And that, if generally speaking, a creditor will support a plan that they believe in. And that leads me to step 3, which is once you've formulated your view and recognize who your important creditors are and devised a plan, understand who you need to help put that plan in place. If you're a well-developed large organization, you'll probably have a capable CFO and management team who can weather you and steer you, but you may not have that. You may want to consider, do you need to hire an external CEO or CFO for a time, or an accounting firm to help you through this, help you understand your cash position? Are you going to face the difficult question of do you need all your employees? Do you have to face layoffs? And if so, do you need an employment lawyer, someone like David Law, to help you? Do you need an insolvency lawyer or trustee, or do you not? You know, the right team of advisors will help you shape your plan and execute it, and then that leads you to that big important meeting with your creditor and setting things on the right foot. And that meeting is one where you have to be frank, but strategic, focus on your plan, and if that plan gets buy-in, everything else will fall away. It won't be easy. Restructurings are but it doesn't last forever. It'll last probably a few months, and then if you do it right, you can come out a stronger, more efficient, leaner organization.
Thank you. That's very helpful, Pavle. I'm going to turn to Jason, if I may. The next question is this. Of course, businesses not only owe money, but are owed money. What do you suggest is the best way to proceed and collect what has to be collected?
Well, I hate to sound like a broken record here, but have a plan. Approaching your accounts receivable or monies that are due and owing to you or your company is like anything else that Pavle was just mentioning with respect to restructuring. it requires an organized, strategic approach. And I would recommend, from personal experience, because we've done the exact same thing in our business, I would recommend prioritizing the accounts that you know you can collect on, and go after those ones first. And so, you know, we call it the low-hanging fruit. Well, they're low-hanging because they're easy to get. Your next step would then be having a look at your list and prioritizing some of the accounts that might be larger, some of the accounts that may be larger and with companies who might be suffering disproportionately as a result of COVID, and attacking those accounts creatively, and potentially going back to your customer or your client and trying to work out a solution, be it a payment plan or a reduction in the fees that are due and owing, or I guess something else that some other creative solution. We sometimes call it expanding the pie. Well, how do you expand the pie? Well, you've got to ask questions. You've got to engage your customers and clients about what they can do. And maybe it isn't necessarily paying out the full invoice at once, but it might be something over time. And perhaps there's another service that they can provide you that provides your company with value. And so just, I guess, to summarize, I would go after the ones you know you can get paid, because as Pavle mentioned, cash is king. And then after that, you tackle the bigger, more complicated problems that may result in either not collecting or having to settle for something else.
Thank you, very helpful. I'm going to be turning to David and Andrew. I understand Andrew is on the line. Welcome, Andrew. We're delighted to see you here. But before we go to David and Andrew, I've got one other question which I'm addressing jointly to Jason and Pavle, and it's this. If a business needs to find new sources of capital, what observations and suggestions do you have?
I'll go first, I guess. Again, this is something that probably requires some internal planning. You may want to sit down with your partners or your existing trusted employees and generate some options. You've basically got three, maybe four options if you're looking for capital. The first option would be going back to your existing banking relationship and having a conversation with your banking institution. And you do one of two things. You would ask for some sort of line of credit if you don't already have one. And if you don't have a line of credit or some form of, funds by way of credit facility, ask for an increase to your credit facility, which may result, I guess, in signing off on some sort of guarantee, which is another discussion entirely, but you may have to give a personal guarantee on that. If that's not an option, you could go external and look for a tier 2 source of funds. There are all sorts of lending institutions out there that would be prepared to lend money to your business. Obviously, it would be a little more expensive. Third, and I think before we go external again, and getting back to my first point, look internally. You may have in your group, you may have some rising stars who are employees who may be prepared to take on an ownership or equity position in the business. And you might want to look at promoting internally and looking for some equity that way. Fourthly, and I guess if you can't look internally, then you're going to look externally. You're going to look for external partners out there, joint venture partners. If you're actually looking to get out of the business, you may look to sell your business, and somebody that might be interested in buying your business would be a competitor. But obviously, I think steps 1, existing bank, steps 3, being the looking internal, would be preferable from my perspective.
Okay, and Pavle, there obviously are dangers when you are going outside the box, if I could call it that, looking for capital. Can you briefly explain your observations in that regard?
Yeah, so the dangers that I would say, and I'll focus really on the tier 2 lender option and the external equity option. The tier 2 lender option it sounds like an obvious danger, but it's something that you might consider without really thinking it through. Is what impact will it have on your primary banking relationship and your other existing creditors? Will it accelerate an already deteriorating situation? Because tier 2 money is fine, again, if the plan provides for it to be paid out and it is clear that it's not putting anyone in jeopardy. But if anybody involved with your business looks at that tier 2 money and says, well, this is going to, these fees are going, the business can't afford these fees, it can cause ripple effects and problems that may not be obvious. So really think carefully and strategically how you're going to get out of it and how you're going to communicate that plan to people who your business's stakeholders. And as for the equity piece, one thing that I've seen time and again, unless you're looking to exit your business, I would never advise a client to give over more than a minority stake, so more than 49% of your business, or whatever that may be, that you have left to sell in terms of equity position. So what I see unfortunately happen is people come in and look to buy a minority stake in your business, and but do it in such a way to set traps, for lack of a better word, to ultimately try and take over your business. And there's really two main ones. One is they'll understand your cash position better than you do and offer you a little less than you need to get in the door. And when 6 or 12 months or whatever it is later happens and you run out of money again, they're the source that you have to look to, and they want more equity, and this time they want a disproportionate share, and now you're stuck with a parasite within your entity that's very difficult to get rid of and that you need, and you've given away control. The second is just build in default triggers in the agreement to then become a very aggressive creditor and investor at the same time, which has it's a recipe for disaster and litigation and potentially having your business taken over from you. So the solution is, one, to go back, have your plan and understand your cash position very, very well so you can't be taken advantage of in that way. And two, look to advisors, professionals who can read the agreements and spot traps that you maybe aren't able to see. I mean, you probably have dealt with a solicitor who knows your business. Just send the documents to them. It's a small investment in what can be a very, very big, expensive problem if not handled right. That would be my additions there.
Okay, thank you. That's very helpful. I'd like now to turn to labor and employment issues. I'm going to begin with David, if I may, and then we'll move on to Andrew as well. David, if a business has to downsize, what observations, stated as briefly as you can, what observations do you have as to how they should go about it?
All right. Well, people should remember that when they employ someone as an employee, which is most of the time, the relationship, whether on paper or not, is a contract, and a person acquires service, tenure, as she works for you over time. Under the common law, she's entitled to notice of termination, which means either actual notice of time ahead of time that she's being released, or where that's not possible or suitable, money instead of notice. There is the common law, which requires that, and which Andrew will tell you because Andrew's very, very good at this. The common law notice can amount to, on average now, a month per year of service for a wide band of employees. Within that, there are also employment standards obligations of notice and sometimes severance to be paid to a person when they're terminated. I'm starting with that because when we lay someone off temporarily for a period of less than 13 weeks in most instances, we aren't yet terminating them under the Employment Standards Act, although we might be under common law. We might be in a position where we can wait to see whether we can bring them back and avoid the termination payout. But if we reach a point of termination either because of the clock running past 13 weeks or because we know we have to do it, that will trigger these obligations. And it's important for people to understand, confronting that the worse the economic situation is, the worse the market for someone seeking work, the more time they'll need to find work, the more notice an employer may owe. That's important to know. Secondly, that the fact that you are in trouble as an employer or an organization and need to do this in no way alleviates your obligations to the individual under the contract. So that means you have to look very hard at termination decisions because they're going to trigger potential and costly liabilities to the individuals affected. Do you really want to go there? Can you afford to go there? Are there ways to avoid it? That's the big Megillah, as my father used to say, waiting for you if you don't manage that carefully. So I'll start with that, and then I'll pass the baton back to you, Dawn, and perhaps you can go from there with Andrew.
Yeah, I'm going to pose a question to Andrew in just a moment, but obviously it's not as simple as simply reducing working hours, putting people in part-time positions.
No, that constitutes a constructive dismissal. Yeah.
Okay, so I turn to Andrew now with a further question in this area. If a business has to go through such a downsizing, how is it best advised to try to keep key employees in the business?
To keep key employees in the business? Is that what you asked?
Yes.
Okay. It's an interesting question. See, to me, there would be no problem keeping key employees in the business as long as you're paying them. Why would they want to leave if you're paying them?
Well,
So
let's assume, Andrew, for the purpose of the question, that frugality is necessary,
right.
cash is short. How do you go about keeping the employees you really need?
Well, the first thing I would say in answer to the question in a general way is, and it'll sound self-serving, but if you're going to be terminating people during this period of time or any period of time, and you're not sophisticated in labor and employment law, then you should be contacting a labor lawyer, because there are a whole bunch of things that the lawyer can do with you to ultimately save you money. Just to go over some of the problems that David has articulated. One of the things he didn't touch on is that if you're reducing your workforce by more than 50 people, there's a triggering under the Employment Standards Act that you have to be conscious of. And that's over a period of time. It doesn't necessarily mean at one time. So if you've, over a period of 6 months, you've laid off 50 people, you will be triggering both termination pay and severance pay. The 13 weeks that David talked about, if you reach an agreement with your employees, that time period can be extended under the Act. So that's always handy to know. It's become such a complicated area of law. It wasn't when I first started. You basically had to know the Employment Standards Act and the Labor Relations Act, and you could go and do that. David will attest to that. That was the simple days. Now it's the Occupational Health and Safety Act, the Human Rights Code, the Charter of Rights, the Labor Code, et cetera, that become involved in it. You want to keep a good employee? Sit down with the employee and talk to them about what it's going to take. There's
Okay.
nothing for that.
What about the prospect of offering the employee, the key employee, an equity position in the company?
One of the things that I don't do for employers is tell them what they should do in terms of that they know their business better than I'm ever going to know their business. What I can tell them is the consequences of that. If you make a key employee a partner in your business, it gets complicated when you want to terminate that employee. So I can tell the employer all of the downsides and trouble spots about doing that. Ultimately, it's up to the employer. Listen, if that's what it takes to keep a key employee and your business doesn't run without them, I don't see you have any choice. You go and do it. Give them the equity position, and away you go. But every action has an equal and possibly negative reaction.
Okay, thank you. Tim Newton, have further questions coming on chat that you would like us to deal with right now, or should we just carry on with what we are doing?
Thanks for asking, Donna. I think what we're doing right now is covering several of the questions that I've seen pop up. So keep on going. This is great.
Okay, thank you. I'm going to address myself, if I may, and do it as briefly as possible. One question which did come up when we were preparing this session, and it's a very interesting question. Can one argue that a contract has become impossible to fulfill? The brief answer to that question is yes. It is possible to make that argument, but it is difficult to win the argument. Now, without going into undue detail, there are two possibilities with regard to one such argument. The first is the common law doctrine of frustration. Sometimes the court will say that supervening events of an overwhelming nature have frustrated the intent of the contract, and the contract will be set aside. Most of the law relating to that actually developed in wartime Britain, where factories were bombed and so on and couldn't supply pursuant to contracts they had entered into. That argument is very difficult to succeed on, and I have not seen anybody succeed on it so far with regard to COVID-19. The second possibility is that your contract has what is called a force majeure, F-O-R-C-E, M-H-A-E-U-R-E, a French expression imported into our law, a force majeure provision in it, which allocates or attempts to allocate the risk relating to unforeseen events. Most business contracts in Ontario do not have such provisions. Some do. But you should keep in mind, and this can be discussed in greater detail on another occasion, you should keep in mind that once again, the courts are very reluctant to set aside contractual agreements and will only do so where on a strict interpretation of that clause, that is the result that is mandated. So I thank the registrant who sent into us that question. It's a very pertinent question, and it's a complicated area of the law. I return next, if I may, please, to Pavle and Jason, who could each answer in turn, if you would. What protections are possible for business owners with regard to personal guarantees of the indebtedness of the business?
Thanks, Don. I don't mind taking first crack at this. I'm just going to tell you a little bit about what the personal guarantee is. It's a document. If you haven't seen one already in your business life, you may see one soon. Generally speaking, a bank may ask you as a business owner to execute one of these as basically a security for repayment of the corporate debt. The personal guarantee is just that. It's a guarantee for repayment, but what you're offering up are your personal assets. And so that's when things, I guess, get a little more serious from a personal perspective. And so when you're looking at one of these documents or you're presented with this document from your bank manager, I encourage you to get independent legal advice. Too many times in my professional life, I have met with clients who have already proceeded to signing one of these things, not fully understanding what they mean, and then asking me to defend a claim on a personal guarantee with various defenses that are available. But I can say that usually these defenses don't work. I can tell you that these guarantees are now more or less standardized. They're standardized forms. They've been challenged right up to the Supreme Court of Canada on various fronts, and they've been flushed out and revised, and they are in such a form now that the likelihood of challenging one of these personal guarantees is slim to none. And so I guess getting back to my first point there, if you are presented with one of these, if you haven't signed one already, but you are in the process of going through it, I do recommend that you get independent legal advice just so you understand the ramifications of it and what it means.
Okay, and Conley, what would you add on this difficult topic? Because it's very, very common for banks particularly to demand personal guarantee.
Yeah. I would say, I mean, the most important thing I would think to give as a bit of general comment is two of the most common misconceptions I see in my practice about personal guarantees are as follows. One, that that the lender, whoever you're giving the guarantee to, has to go after the business before they have to come at you after you. That's not true. That's part of the whole point of a personal guarantee, is to give the lender easy access to assets they know you have, so that if they get underwater, they don't have to go through the uncertainty of suing a business which might, or might not be able to satisfy any judgment and might have complications in suing. They can just go straight to the guarantee, or sue. Usually they'll sue both, but get a judgment against everybody. And that's something that I think commonly people don't appreciate, is that they don't have to go after the principal debtor first. They can go after everybody at the same time. The second very common misconception is that the guarantee is somehow fixed to the whatever loan it was initially tied to. That's generally not the case. Usually any lender will offer what's referred to as a continuing accounts guarantee. And what does that mean? That means that the guarantee will be structured in such a way as it guarantees all of your debts to the creditor forever, until the guarantee is canceled or until you never owe them money. So let's say you sign your first guarantee with a bank for a line of credit for $100 grand, and it's 10 years ago, you've forgotten all about it, and your line of credit has now increased to $1 million. You might think that that guarantee is only up to 100,000, unless the guarantee says that, and it's probably actually guaranteeing up to $1 million. And so you need to understand that, and you should probably look at your guarantee anytime that you're being asked or looking for the bank to provide you more facility to confirm whether you have a continuing accounts guarantee. You might also want to look at who's actually a guarantor on it, because sometimes people will exit a business and find out later that they've been sued as a guarantor because they never bothered getting the bank to sue to release them from their guarantee. That was just one of the things they didn't do when they engineered their exit from a business. So these guarantees can come back to haunt you in a business you don't even own anymore. That would be what I would add to that. Guarantees can be tricky, and to ape what Jason said, you should get your advice on them, because they are serious in the sense that they're an attack on your personal wealth or potential attack.
Thank you. I'm going to return now to David and Andrew, and another area which can be fraught with difficulty, especially as businesses are attempting to reopen during the COVID-19 pandemic. What health and safety rules and regulations must the business keep in mind, and can employees refuse to come back to a workplace that they consider to be unsafe? And in what circumstances do you have to deal with employees who say, no, I'm going to work from home from now on? Thank you very much. So Andrew, would you like to address that first, and then I would ask David to follow?
Sure. Well, I think every employer has to sit down and reevaluate how the business is being run and how it's being done. And there's not necessarily a detriment to having employees working from home. They might feel more comfortable. I can tell you that the insurance companies and banks have been doing this for years, long before there was COVID, and they see very positive results from that, or they wouldn't continue doing it. So that would be the first thing I would do, is do the analysis. And then there's something, employers, I think, sometimes underestimate the importance of the morale of their workforce. But I've seen lots of great companies, great ideas, great new innovations scuttled by unhappy employees who just drag their feet and make sure that it's not successful just because. And entering into a dialogue with an employee about where they're going to work, you know, life's a little bit different. When my dad described his work, he was a maintenance electrician in a plant, told me that he would have to ask for permission to go to the washroom, and sometimes he didn't get it. And that was 50 years ago, and that's how businesses were run back then. And we're different now. We coach our performance out of employees rather than order performance out of employees. And I don't think that's necessarily a bad thing, but it means that you as an employer have to develop a dialogue. And there are cases where you absolutely need the employees coming in. You do trigger human rights concerns if you are forcing an employee to come in who has a compromised immune system or someone at home with a compromised immune system. I don't think you want to be on the other end of that litigation, terminating an employee who hasn't come in for those reasons. It just doesn't seem, it doesn't make business sense to be in that. And it doesn't make humanitarian sense. And if you want to be a good humanitarian, and I think good employers do want to be good humanitarians, then sit down with the employee, figure it out, and there's always a good compromise.
Okay, that's great. And David, I wonder if you could add to this, because I think it's important for the registrants to understand what the obligations of the employer are to provide a safe working environment. Could you explain that briefly to us and add to what Andrew has already very helpfully said?
So the Occupational Health and Safety Act in Ontario requires employers to take reasonable precautions against any risk. And it doesn't specify necessarily particular diseases or pandemics, but of course that would include COVID. Where any worker in the province believes that he or she is at risk of an extraordinary danger at work, of being injured imminently, or subject to an exposure, that person has an absolute legal right to decline to do the work that they think is dangerous. And the employer has an absolute legal duty to respect that decision, to evaluate the circumstances, and then to make a judgment. Is the individual correct about the risk? Have I not understood all the factors here? Or is the individual incorrect? And then to have a conversation with the person about either way, which way that risk assessment has gone. I've been doing this a long time, and I haven't met a lot of people who are prepared to be insubordinate and refuse to do their work for no reason at all. If a lot of people think that they're at risk, they're going to be cautious and worried about coming back. And we have, after all, been through the last 4 months of the government terrifying us all regarding our vulnerability to exposure to the pandemic. And they did a pretty good job of terrifying us all. And in fact, look at our results in Canada. Exceptionally good compared to a lot of countries, not just our neighbor. And it's because people took it seriously and they're being careful. So when it comes to people who don't want to come back to work because they're concerned about exposure, our obligations as employers is to listen to them, to have a conversation, to involve a member of the Workplace Health and Safety Committee or a health and safety rep in the assessment of the risk. And it will vary from person to person. Andrew mentioned persons with particular vulnerabilities. It may well be that worker A is more vulnerable to a risk than worker B, either to the exposure itself because of what they do, or with respect to their own effects should they get sick. Finally, in terms of practical things for the audience to know about when it comes to preventing hazards, Ontario has issued a lot of guidance for industry sectors. It's all available online as to how your workplace can be kept safe by taking particular measures. It's very good stuff. It's all straightforward. It's not complex. And the one thing about it that's probably wrong now, because the guidance hasn't been updated necessarily, is of course the mask. When we all started this, the mask was a question mark of some controversy. Now it pretty much isn't. Now we all have them, and many municipalities like mine, Jason's, others, are requiring people to wear them in indoor public spaces. The mask is a good safety tool. That plus the measures Ontario is offering to workplaces with respect to distancing, shielding, hygiene, work from home, etc. Do these things, give people confidence that you are going to keep them safe. And what you're going to get for that, aside from people coming back to work, is you're going to send to your employees a simple message: I respect you, I respect your dignity. I'm not going to ask you to do something I wouldn't ask myself or someone close to me to do. It's the golden rule, and it's a good one to follow, and it works. So that's, I guess, the nutshell version of it, Don.
Yeah, just one supplementary question there, David. What about, just for good measure, a business retaining a knowledgeable consultant to assist with regard to making sure the workplace is as safe as possible given COVID-19?
Well, we're lucky. I mean, the vast amount of tax money being spent on this project has produced public advice, which is pretty good. I think that what I'm certainly seeing in a lot of workplaces and businesses is this: it's really hard for people to learn this stuff. Even wearing the mask, following the arrows in the right direction in the office. I got called out on that yesterday, by the way. But you know why? Because it's simply new and different for us, and getting people to learn new ways of interacting with each other in person. This is we're working up against thousands of years of learned habits, and right now we're trying to break those habits. So training and coaching is a really good idea for everybody when it comes to following these practices. And if you don't know what you're doing around them, you should get advice, not just for practical reasons, but also for legal ones, because as the others here will tell you, if you get good advice about something and you get it wrong, you at least may have been duly diligent. Whereas if you simply make it up as you go along and don't follow good advice, don't do that, what have you been doing, and how do you prove the effort to keep people safe? By the way, last note, everybody who works for you has a brain in their head, and they all know things about this and have ideas, and we're all facing something new together. I strongly encourage employers to reach out to employees and find out what they know and think. Some of it will frighten you and worry you. Some of it will be illuminating, but it's a conversation we have to have.
Okay, good. So we're approaching 4 o'clock, and I would like to end on the same sort of note that we began. We began with innovative business solutions and bright spots, notwithstanding this current crisis, and plowing through it and achieving something. I'm wondering if the panelists have any further observations in that regard. It isn't all gloom and doom, and the registrants to this program, of course, want as many bright ideas as they can. So, Jason, Pavle, I leave it to you, which of you would address that. But what other thoughts have occurred to you?
I guess just in closing, I would suggest that we not look at or approach this pandemic and what we're facing as just as a community. I mean, it is what it is, but I think we can be opportunistic. I think we can see things glass half full. There are opportunities out there, and we will, as I said at the outset, we are a resilient bunch. We will get through this. And I think the more opportunistic and the more glass half full we approach things moving forward, the better we'll be.
And Pavle, would you add something to that?
I would, and it's along the same lines. One of the big opportunities that I see coming down the pipe is consolidation in industries, and a lot of people, I mean, viewed the wrong way, that can be seen as a frightening thing. It isn't. It's just change. A lot of industries need to become more efficient, and consolidation can be very healthy, and it can be very profitable. I mean, if you're a larger organization with some smaller competitors, this could be an opportunity to strengthen your business by buying some very good assets. And similarly, if you've been looking to exit and you see there's some consolidation coming, now is a time to really take a good hard look at whether there's a plan that makes sense right now to ride that wave and sell for a fair and good price and exit. With all this change coming, if you don't want to confront it. So it's not change is not necessarily negative. It's only negative if you make it so, but it can be a very positive thing, and there are lots of opportunities depending on what sort of business the various listeners in today are in.
And Andrew, anything to add in that regard? Have we lost Andrew? I hope not. Dave.
Forgot the I've recently been on a panel demonstrating how to conduct Zoom hearings, because that's the world that we're facing as lawyers. We're going to be doing more and more hearings and court appearances by Zoom. And what struck me is there was a whole bunch of hand wringing from the participants. There was about 75 lawyers. They're all wringing their hands about how difficult it was going to be to conduct hearings and court appearances by Zoom. And by difficult, I assume what they mean is different. And it certainly is different. There are similar skills. That's the way I've described it. It's the difference that an actor has to go through appearing in live theater and appearing in a movie. They're very similar, but there are some nuanced differences. What I find is that because I've embraced the concept of Zoom hearings, I'm overloaded with business that involves litigation. Those people who are wringing their hands and are worried about that change are missing the boat. So the big message I would say to employers is, if you embrace the change and are nimble, then you're going to be the one that takes advantage of it. It actually is an opportunity that, if you embrace it, that you can take advantage of.
Thank you, very helpful. And David, anything to add in that particular regard?
Yes, I guess this. We have unexpectedly just all together gone through, and maybe still in the middle of, the weirdest and hardest experience of our lives. That's actually what's happening. And people are stressed out, people are tired. It never seems to end. Who doesn't wake up and wonder, is it over now? And it never is. And we don't know what the future will be, where the escape will be. What's the point of that? Everyone that we're dealing with, everyone that you employ or who works for you, has been stressed out and worried and afraid. And people make bad judgments when they are in that state of mind. They sometimes make mistakes they ordinarily wouldn't. And what I'm strongly counseling my clients is even more than usual, which is, when you make a decision, stop and don't make it. Stop and think again about that. Take a breath. Everyone is tired and everyone has been worried, and we don't know what's going to happen. So you may not be at your best, and others may not be either. And so if someone around you is particularly difficult or obnoxious and you'd really like to fire them even more than before COVID, or something like that has happened, take that breath, remember what we're all going through, and be forgiving with yourself as you are with others. And I think that that point of view has allowed me to get through some of the harder moments of practice in the last 4 months. I expect it will assist me in future. And of all the lessons I've gotten so far from this, that's the one I would offer to all of our friends listening today.
Thank you. So I'd like to thank all of the participants. You've made some excellent points, which we hope are useful to all the registrants who have been listening. If registrants have further questions, which they would like to discuss in a confidential setting, they can reach me, Don Jack, at 416-301-4926, or here in Collingwood, Scott Thompson at 705-445-7559. I would like to thank Tim for assisting, moderating this matter, and setting it up. It's been a very useful discussion, in my estimation, and thanks to everybody.
Well, thank you, Don, Tim, everybody on the panel. Thanks, folks, for listening today.
Yeah. Thank you, everyone, for inviting us to speak today and for listening.
Thank you all. From our perspective, this has been a fantastic discussion, a fantastic panel of assembled experts. So for sharing your opinions, your insights, your expertise and your knowledge, we thank you and we appreciate it. I would also like to thank those in the background, so Karen Clegg, Johanna Griggs, and Irene, for all of your work in pulling this panel together as well. It certainly wasn't just me, that's for sure.
Here to that.
I would also like to echo Don's statement. If there are further questions that you come to think of this evening while you're lying in bed, please don't hesitate to reach out. We can help to connect you to the expertise, information, and supports that you need. Remember to check the simco.ca Ask an Expert website link for upcoming events and for recordings of both this event and previous events that we've hosted. Our next event, as a reminder for everyone, takes place on Thursday, the 16th of July at 3 p.m. And that's an Ask the Expert on an open conversation on supporting mental health, which is certainly something at the forefront of most people's minds in this day and age. Again, thank you to everybody, and we wish you all the best.
Thank you.
Thank you.
Bye for now.